Hello, my dear students. Today we'll continue with the constitutional validity of Minimum Wages Act, as we have covered in the previous session. And you all are aware that we are discussing Minimum Wages Act 1948, important provisions given under the Act. And this is unit number 1 of labor law, second paper. And we have seen that this Minimum Wages Act is not unreasonable, and we have seen the Minimum Wages Act from the Article 14 point of view also, Article 14 of the Constitution. Now, further, we'll talk about the constitutional validity of the Minimum Wages Act, and today we'll talk about the notification fixing different rates of minimum wages for different localities is not discriminatory. For this act, Minimum Wages Act 1948, notifications, for fixing different rates of minimum wages for different localities is not discriminatory. So why it is not discriminatory? That So notification fixing different rates of, minimum wages for different localities is not discriminatory, and where this fixation of rates of wages under wages and their revision were, manifestly preceded by a detailed survey and inquiry, and the rates were brought into force after a full consideration of the representations which were made by a section of the employers concerned. And it would be difficult in the circumstances to hold that notification which fixed different rates of minimum wages for different localities was not based on intelligent differentia and having a rational, nexus with the object of the act. And when the government issued notification improving upon the existing minimum wage as revised minimum wages, disregarding the contrary report of the committee appointed under Article, under Section 5(1) Clause A, such notification was bad under the law and was to be made inoperative. So this notification fixing different rates of minimum wages for different localities is not discriminatory. And where this fixation of rates of wages and their revision were, manifestly preceded by a detailed survey and inquiry, and the rates were brought into force after a full consideration of the representations which were made by a section of the employers concerned. And the notification for fixing different rates of different wages, minimum wages for different localities is not discriminatory, we can say. And as I pointed out by one of the India's Union Labour and Employment Minister, Shri Mallikarjun Kharge ji, the former minister, the variation of minimum wages between the states is due to the differences in socio-economic and agro-climatic conditions, prices of essential commodities, paying capacity, and productivity and local conditions influencing the wage rate. And the regional disparity in minimum wages is also attributed to the fact that both the central and the state governments are the appropriate governments to fix, revise and enforce minimum wages in scheduled employments in their respective jurisdictions under the Act. So the former minister also emphasized that this difference in the minimum wages is because of the socio-economic and agro-climatic conditions, prices of the essential commodities, paying capacity of the establishments in the different geographical areas, and productivity and local conditions influencing the wage rates. And the Constitution of India accepts the responsibility of the state to create an economic order in which every citizen, finds employment and receives a fair wage. And this made it necessary to quantify or lay down clear criteria to identify fair wage. So, therefore, a Central Advisory Council in its first session in November 1948 appointed a tripartite committee on fair wages And the committee consisted of representatives of the employers, employees, and the government, and their task was to inquire into and report on the subject of the fair wages of the labor. So this Constitution of India, as I told you, accept this responsibility of this state to uh, create an economic order in which every citizen finds employment and receives a fair wage, right? And this made it necessary to quantify or lay down clear criteria to identify fair wages. Now we talk about the sanctity of the Minimum Wages Act 1948. So Supreme Court in three separate rulings has held that non-payment of minimum wages is tantamount to forced labor. So if any employer is not paying the minimum wages to the workers, so it would be treated as he is involved in forced labor, which is prohibited under Article 23 of the Constitution. And the Supreme Court holds that forced labor may arise in several ways, including compulsion arising from hunger and poverty, want and destitution, right, in Sanjeet Roy versus State of Rajasthan. And Supreme Court held that the Exemption Act, insofar as it excluded the applicability of Minimum Wages Act 1948 to the workmen employed in the famine relief work, is clearly violative of Article 23, and thus even public works ostensibly initiated by the government for the sole purpose of providing employment are subject to the Minimum Wages Act. And this act, the act and the judgments are in favor of equality provided under Article 14 of the Constitution, and a judgment in the case, namely Engineering Works Union versus Union of India, pronounced the judgment that the provisions under Section 32A, that minimum rate of wages in a scheduled employment fixed or revised shall not apply to the employees during the period of adjudication, violated equality clause of Article 14, and hence that section is void. And in the view of the directive principles of the state policy, as contained in the Article 43 of the Indian Constitution, it is beyond doubt that securing of living wages to laborers, which ensures not only their physical subsistence but also the maintenance of health and decency, and it is conducive to the general interest of the public. And the Minimum Wages Act was passed to fulfill the aspirations as contained in the following resolution, that if the laborers are to be secured the enjoyment of minimum wages and they are to be protected against exploitation by their employers, it is absolutely necessary that restraints should be imposed upon the freedom of contract, and such restrictions cannot be said to be unreasonable. So if the laborers are to be secured the enjoyment of a minimum wages and they are to be protected against exploitation by their employers, it is absolutely necessary that restraints should be imposed upon the freedom of contract, and such restrictions cannot be said to be unreasonable. Why? Because see, employer is having the power of money and always in a position to dictate the terms. So it is necessary that we should restrain or we should impose upon the freedom of the contract, and such restrictions cannot be said unreasonable. And on the other hand, the cannot be heard to complain if they are compelled to pay any minimum wages to their laborers, even though the laborers, on account of their poverty and helplessness, are willing to work even at lesser wages. Even if workers or the laborers are agreeing to work for a lesser amount of money, whatever is prescribed by the Minimum Wages Act or under minimum wages, but still, because worker is will definitely feel, because of the poverty, will feel helpless, and even if the worker is willing to work even at lesser wages, but still employer should pay at least minimum wages to the workers or the laborers. And this is one case, you can refer this case also about the constitutional validity of this act. It violates the guarantee of the, means this act violates the guarantee of the freedom of trade business given under Article 19(1)(g) of the Indian Constitution, right? So you can refer this case also, Vijay Cotton Mills Limited. And in this case, it was held that the restrictions imposed upon the freedom of the contract by fixation of minimum rates of wages interfere up to some that we have already covered, and the directive principles of the state policy as embodied in Article 43 of the Constitution are protected by the terms, Clause 6, that we have already gone through. And fact that the employer might find it difficult to carry on business on settled principle cannot be sufficient reason for striking down the law itself as unreasonable. The poverty of labor is also a factor to be taken into consideration while determining the question whether a particular provision is in the interest of the general public. So this is all for today's deliberation, my dear students, and I believe today's deliberation will help you, right? So you just go through this lecture, and in next lecture we'll take some new topic. Thank you so much. Have a nice day. Have a nice time. Bye bye. Take care.